Hello and kia ora. I'm Liz Hicks, a PhD candidate at Melbourne Law School and Humboldt University of Berlin, currently in Berlin.
And I'm Sangeetha Pillai. I'm a Senior Research Associate at the Caldor Centre for International Refugee Law at UNSW, and I'm on the land of the Gadigal people in Sydney.
We'd like to begin by thanking Joelle for inviting us to present on key public law developments in Australia in 2021. I'd like to also thank Sangeetha for jumping in to help me present today and for putting up with all my technical problems with Zoom recording. Today, we are going to talk about three cases that were decided in the Australian High and Federal Court in 2021. We've chosen those cases because of what they say about the incredible breadth of executive power in control of the international border, which in 2021 became an area of law at the forefront of public attention because of the response to the COVID-19 pandemic. We've chosen the first of our cases, AJL 20 in the Commonwealth, because of its legal significance in affirming the incredible scope of the executive's power to detain unlawful non-citizens. The other two cases, Newman and Minister for Health and Aged Care and Djokovic and the Minister for Immigration, are less legally significant, but were cases that attracted extraordinary attention from the Australian public and internationally. In this sense, they are remarkable.
I'll speak first to the AJL 20 case, and as a little bit of context for this case, since 1992, Australia's had a statutory framework that requires mandatory immigration detention for any non-citizen who arrives in Australia without a visa or who has their visa revoked. This statutory framework says that if a person in immigration detention has run out of visa options, the government must remove them from Australia as soon as reasonably practicable. In other words, the purpose of immigration detention is visa processing or removal, and a person's time in immigration detention ends with one of those things occurring. In 2007, in a well-known case called Alcatab and Godwin, the High Court found that where a person's in immigration detention but there isn't anywhere they can be removed to, for example because they're stateless, the statutory framework requires that that person continue to be held in detention even if that detention turns out to be indefinite. And the court also found that indefinite detention of a non-citizen is within constitutional bounds, provided the object of the detention is still to remove the person from Australia as soon as practicable. AJL 20 is a successor case to Alcatab. It involved a situation where an asylum seeker, AJL 20, had been denied a protection visa and was held in detention. For a significant period of the time that AJL 20 was in detention, the government, by its own admission, did not make an effort to remove him from Australia, but instead kept him in detention. This meant that in practice, detention wasn't being carried out for the purpose of removal. After a lower court decision where AJL 20 was initially granted habeas corpus on the basis that his detention was unlawful, the case ended up in the High Court. And the key question before the High Court was whether the fact that the executive was required to pursue AJL 20's removal from Australia and was not doing so made the detention invalid. By a narrow majority, AJL 20 lost the case. The court found that the fact that the government was not pursuing removal did not invalidate the detention because the statutory scheme for detention, which required that detention end only with removal or the grant of a visa, was constitutionally valid. If the government is not in fact pursuing removal, the only remedy available to someone like AJL 20 is a writ of mandamus. This case is significant because it affirms for the first time in Australian law that executive detention will be lawful until the moment that it actually ends.
The second case that we're going to speak to, Newman and the Minister for Health and Aged Care, doesn't relate to powers in the Migration Act. Instead, it concerned the use of an extraordinarily broad power in the Biosecurity Act, Section 477. In April 2021, the Minister for Health and Aged Care relied on that provision to ban people from returning to Australia if they had been in India during the previous 14 days. This happened at the height of the Indian second wave and was motivated by a perceived need to reduce the number of positive cases in hotel quarantine to avoid the risk that those cases would then leak into the community. Before making a determination under Section 477, the Minister had to be satisfied that certain legislative proportionality standards had been met. The Minister relied upon health advice from the Chief Medical Officer, albeit health advice that was itself quite conclusory, to make that determination, and the Federal Court held that the power had been validly exercised. This was because it was open for the Health Minister to reach that conclusion on reasonable grounds. Whether it was the best decision on its merits was not relevant. The court couldn't dig into the substantive proportionality of that decision the way that you may see in systems elsewhere.
The Newman case also had a constitutional dimension. An argument was developed that due to the deep common law links between citizenship and the right of return, Australian citizens have an implied constitutional right to enter Australia, which could not simply be overridden by clear terms in legislation such as the Biosecurity Act. But ultimately, the constitutional part of Newman's case was withdrawn for practical reasons. The administrative law case was heard and decided against Newman just before the 2-week travel ban lapsed, and the ban lifting meant that there was no ongoing reason to answer the constitutional questions that Newman had raised. Part of the difficulty in getting the constitutional law argument heard was that this argument was a very speculative one that lived in an uncharted area of Australian constitutional law. And what this meant was there was next to no relevant jurisprudence to draw on, and the likelihood of having a case heard and decided within the very limited time frame available was unrealistic.
Sangeetha, what do you think these decisions have in common?
Well, I think both these decisions confirm that when Parliament has wide constitutional powers, it can delegate these powers in very broad terms to the executive. Administrative law constraints will exist, but these cases show that those constraints often give the executive a lot of room to move. Constitutional law constraints on executive power are much less guaranteed. Sometimes they don't exist at all. And even where there is an argument that they do, as in Newman, the lack of a clear constitutional rights jurisprudence can make them risky or impractical to raise, particularly in short order. I think something that's also become apparent from the cases over the last year is that there are often a lot of roads to the same end for the executive when it's exercising the powers that it has. And this is something that was really obvious in the Novak Djokovic visa cancellation case. Djokovic, after arriving in Melbourne hoping to compete at the Australian Open with what he believed to be a medical exemption from vaccination requirements, had his visa cancelled at the airport in the early hours of the morning. Djokovic challenged this initial decision to cancel his visa and succeeded because the government admitted that the process that had been followed by the delegate who cancelled the visa at the airport was unlawful. But the immigration minister, under extremely broad visa cancellation powers, then had a second bite at cancelling Djokovic's visa, using a completely separate and very, very wide ground. Djokovic challenged the second visa cancellation too on a number of administrative law grounds, but was unsuccessful purely because of the breadth of the power that was relied on that gave the minister a lot of room to move. Nothing about the outcome in the case was a huge surprise to migration and administrative lawyers in Australia, but the sheer number of roads to visa cancellation and the fact that the government, having basically made a mistake the first time they tried to cancel Djokovic's visa, could simply have another go, was a surprise to many of the non-lawyers looking on both in Australia and across the world. What are your reflections on these cases, Liz?
So what we can see here is how the COVID pandemic has created a heightened public awareness of the extraordinary breadth of executive discretion in Australia and raised questions about proportionality protections in Australia. Crises can often shift established power structures so they affect different groups with a greater platform and visibility. In this case, the scope of executive discretion in immigration and border cases has often affected marginalised communities who lacked visibility in the Australian public eye. Two of the cases here, Newman and Djokovic, are in many respects unremarkable for lawyers, as you know, but they concerned either a high-profile individual, so Novak Djokovic, or an Australian citizen to whose circumstances the Australian community attaches certain expectations about how our system will protect people when they're in circumstances such as Newman was in. We can see that the breadth of the ministerial discretion in these cases excludes the kind of proportionality considerations that you may see in other systems predicated on rights catalogues or where there are more substantive checks on executive power. The tension that these cases have attracted over the past year indicates that there is a gap between what many Australians think the law does and what it protects and the reality. Thanks for listening to us today.
Thank you.